Good morning, ladies and gentlemen. I'd like to welcome you to County Court Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here this morning. You've been asked to come to court for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are concerning your case, and what your options are concerning your case. The case that you have here in County Court at Law Number 2 is a criminal case. Criminal cases are divided into felonies or misdemeanors. The felony cases are what we refer to as your most serious type of offenses, and your misdemeanor cases are referred to as your petty offenses. The case that you have in this court is a misdemeanor case. Now, if you had a felony case, felonies are divided into 5 categories, and we'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine up to $10,000. If a person is convicted of a capital murder, then the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about that because, as I mentioned earlier, the case that you have in this court is a misdemeanor case. Misdemeanor cases are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. You have a Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is a fine from $0 to $5,000. I mean, $0 to $500. So a person cannot be given jail time for being as a punishment for a Class C misdemeanor. Now, Class C misdemeanors are those cases that are normally handled in the city court, which is the municipal court, or the JP court, which is the justice court. However, they come to this court after a person is convicted in the city court or the JP court, and they appeal that case to this court. And once it comes to this court, you have the same punishment range. So the punishment range does not change. It's still $0 to $500. Now, however, if you cannot pay the fine, and if your fine is converted to community service, and if you fail to perform the community service, then the court can issue what is called a capious pro fine. Capious pro fine means that it's a warrant for your arrest to either pay the fine or sit out the time in jail. And if you have to sit out the time in jail, you'll be credited at $100 that will go toward the fine and court costs for each day that you spend in jail. So, for example, if the fine and court cost was $200, you didn't pay it, issued a capious pro fine, that means you would have to spend 2 days in jail. Okay. Now, the next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is 0 days to a maximum of 365 days in the county jail and he fined or a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, you may be eligible for one of two types of probation. The first type of probation, we call that regular probation, or the term that it's really called adjudicated probation. So with the adjudicated probation or the regular probation, you will have a conviction on your record. However, the court can set aside your conviction and by way of what is called judicial clemency. That is, the judge or the court can set aside the conviction if if three things happen. First, you have to successfully complete the probation. You cannot have any more time left on the probation, and you have to be successfully discharged off the probation. And if that happens, then the court, in its discretion, can set aside your conviction, and you will not have a conviction on your record. Now, however, if you get a subsequent offense or subsequent conviction, meaning that if you get a conviction later on, then what can happen is the case that the judge gave you this judicial clemency on can be brought back up. It can be revived, resurrected, or brought back up and used against you. And if you try to get a license with CPS, then they could either deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, the other type of probation is called deferred adjudication, which is called unadjudicated probation. And with the unadjudicated probation, once you get on probation, you do not have a conviction on your record. And if you successfully complete the probation, the unadjudicated probation, the case will be dismissed. You will not have a conviction on your record, and you may qualify for what is called a non-disclosure. And what a non-disclosure is just simply means that we cannot disclose or tell the general public that you were on probation for this particular offense. Now, if you do, as I mentioned earlier, if you do qualify for a non-disclosure, you would have to get an attorney to make application for you. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is the right to have an attorney. Now, the first page on the clipboard is titled Judge's Explanation of Rights to Defendants Without Attorney. And it states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. That's your first option. Number two, if you do not have enough money to hire an attorney, you may request or ask that an attorney be appointed to represent you. And number three, if you want to waive, which means to give up your right to have an attorney, or waive your right to have an attorney, or give up your right to have an attorney, then you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset, which means that you'll be given another court date from today. You'll be given another court date to give you time to hire an attorney. If you do not have enough money to hire an attorney and you would like to have an attorney to represent you, then you must fill out a financial questionnaire. Now, the financial questionnaire should be the third page on that document that is titled Jefferson County Affidavit of Indigence. You'd have to fill out the first page and half of the second page, and the proper person will determine whether or not you qualify for an attorney to be appointed to represent you. Now, if you want to waive your right to have an attorney, give up your right to have an attorney, you would like to represent yourself, then you'll be allowed to speak to one of the two prosecutors that are here in court. Okay? And with one of the two prosecutors, you'll be allowed to speak to them. Why? Because you are representing yourself. In essence, you are your own attorney. You have waived or given up your right to have an attorney. Now, you may not speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. The written waiver is the second page on that document that's titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. So that's the second page on that clipboard. You would have to read and fill out that document. And then once that's done, then you'll be allowed to talk to one of the prosecutors about your case. Now, I'm going to go over that document with you in a few minutes. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to waive or give up your right to have an attorney and you want to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that first document that's titled Judge's Explanation of Rights to Defendants Without an Attorney, in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to request a court-appointed attorney to represent you, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you want to waive your right to an attorney or give up your right to have an attorney to represent you, and you want to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled Defendant, and you will date it today's date, February 27th of 2024. Now, for those individuals who will be waiving their right to an attorney and representing themselves, the next page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial, and it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily, which means that nobody's forcing you to enter a waiver, and intelligently. Intelligent means that you know what you're doing. So my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 27th day of February 2024 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled Defendant, and you will date it today's date, February 27th of 2024. Now, as a defendant in a criminal case, you have other rights. One other right that you have a right to have a trial by jury. Well, the young lady is sitting in that area. We call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to the evidence. They will listen to the arguments of the attorneys, and they will deliberate. And after they deliberate, they will decide to find you either not guilty or guilty of your charge. You also have a right to waive your right to have a jury trial, which means you have a right to give up your right to have a jury trial. And by doing so, you will not have a jury. Your case will come before the court in one of 3 ways. One way it will come before the court is by way of a bench trial. A bench trial means that it's a trial by judge only. The judge will listen to the evidence, listen to the arguments, and then the judge will decide to find you either not guilty or guilty of your charge. Another way that your case can come before the judge is by way of an unagreed plea bargain. Now, what a plea bargain is, it's an agreement that you work out with the district attorney's office to settle your case. If you are unable to come to an agreement with the district attorney's office to settle your case, and you still want your case to be settled, then you will come before the judge by way of an unagreed plea bargain agreement. That simply means that you and the state have not been able to reach an agreement, but you want the judge to decide what your punishment will be. And the judge will decide what your punishment will be within the punishment range that you're charged. Now, if you and the state come to an agreement, then we call that an agreed plea bargain agreement. And so your case will still come before the court, but when it comes before the court can do one of 2 things. The court can either accept or reject the plea bargain agreement. Now, if you have a plea bargain agreement and the court rejects your plea bargain agreement, and I'll just give an example. Let's say you and the state has reached an agreement for you to be placed on deferred probation. And it comes before the court and the judge says, well, I'm not going to follow that agreement. I'm going to reject that plea bargain agreement. If that happens, if the court rejects your agreement, then you can withdraw or take back your plea. So for example, the judge says, well, I'm not going to accept the plea bargain agreement for deferred probation. In your case, you can say, well, judge, I withdraw or I take my plea back. You can do that. Now, if the judge accepts or follows the plea bargain agreement and you decide within 30 days that you would like to appeal your case, in essence, you would like to have a higher court than this court to review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. And if you want to appeal your case after the judge has followed the agreement, you have to get permission from the judge to appeal your case. Now, if the judge gives you permission to appeal your case, then your case will leave this court and it will go to the Ninth Court of Appeals, which is right above us on the 3rd floor. They will review your case and they can do one or 2 things. They could either grant your appeal or deny your appeal. If they grant your appeal, they could just simply find you not guilty. Or they could send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, Then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals, which is located in Austin, Texas. It is the highest criminal court in the state of Texas. Now, you would have to file what is called a pro se petition for discretionary review. Pro se means that you'll be handling this on your own without an attorney. And the court the Court of Criminal Appeals could either accept or reject your pro se petition. Now, if they accept your pro se petition, they could just simply find you not guilty. Or they could send your case back to the Ninth Court of Appeals or send it back to this court and order this court to give you a whole new trial. If they deny your pro se petition, then at that point, your conviction will stand. Now, as a defendant in a criminal court, in a criminal case, you also have a right to have witnesses to come to court to testify. Witnesses sit in that chair that I'm pointing at, the chair with the microphone in front of it. They can either testify for you or against you. If you're representing yourself, you can ask them questions. If you're represented by an attorney, the attorney can ask them questions. We call that either direct examination or cross-examination. You also have a right to waive your right to have witnesses, which means you have a right not to have witnesses. In essence, you have a right not to call any witnesses in your case. Now, if you waive your right to have witnesses in your case, that simply means that you will not be calling witnesses. It does not mean that the state of Texas or the district attorneys will not be calling witnesses, because they will be calling witnesses in the case. You also have what is called a Fifth Amendment right against self-incrimination. You may have heard the term, I take the fifth. In essence, I'm not saying nothing. And basically, as a defendant in a criminal case, the state of Texas, the government, the district attorney's office cannot force you to take the witness stand to testify against yourself. If you invoke your Fifth Amendment right or exercise your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. Now, if you waive or give up that right, then you can testify in your case. But if you do not waive it, the state cannot force you to testify. You also have a right to have discovery. Discovery means you have a right to see the evidence that the state will be using against you. For example, you have a right to see witness statements, your statement, police reports, lab reports. You have a right to see video recordings. You have a right to listen to audio recordings. You have a right to see any instruments that they may be using. Now, you have a right to have access to that. That does not mean that the state, if you're representing yourself, have a right to give all of that stuff to you. Now, your attorney will be provided with copies of videotapes, copies of reports, etc. They have what is called discovery. So you have a right to discover or see what's in the state's file, to see the state's evidence that they'll be using against you. Now, everyone that's here today for arraignment, that's on the arraignment docket, you have been arrested, you're bonded out of jail, and you're out of jail either on a cash bond, which means that you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a percentage of the bond to a bondsman to get out of jail, or you are out of jail on what is called a PR bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You just released under your own personal recognizance with a promise to appear here in court today. Now, every day that you have spent in jail, that jail time, if it's just 1 minute you spent in jail, that's considered a day because you was in jail for that day. So every day that you spent in jail, it can be used as credit towards your punishment. If the state is offering you jail time, now every day that you spent in jail, you get credited, for example, if you, let's say you spend 5 days in jail, and let's say you and the state have reached a plea bargain agreement that you will spend 5 days in jail as your punishment. Well, you would not have to spend any more time in jail. Why? Because you've already spent 5 days in jail. Therefore, you'll be given credit for the time that you have already served. If the state is offering you 7 days in jail and you spend 5 days in jail, that simply means that you would have to spend 2 days in jail because you've already spent 5 days in jail, and we're going to subtract the 5 from the 7. We get 2. Now, every day that you spent in jail can also be used as credit towards your fine and court costs. So you will receive $100 per day that will go toward your fine and court costs. So if the state is offering you fine and court costs of $500, you spent 5 days in jail, you will not have to serve any more time in jail. Why? Because you've spent 5 days in jail, and your 5 days in jail is $500. So the fine and court costs will be taxed and retired, which means you won't have to pay it because you've already served enough time in jail to pay it off. Now, if they're offering 7 days in jail, you spent 5 days in jail, or if they're offering fine and court costs of $700, and you spend 5 days in jail, 5 days in jail is $500. So we take 500 from the 700, that leaves $200. So that means that you would have to pay $200. Now, if you cannot, now that $200 will be paid on the same day that you enter your plea. If you cannot pay the $200 on the day of your plea, then what can happen is we can convert the $200 to community service, which means that you can work in a nonprofit organization, and every 1 hour that you work at that nonprofit organization, $12.50 will go toward the payment of your fine and court costs. So, for example, if you work 8 hours, that's $100 that will go toward your fine and court costs. So in our example, you work 2 8-hour days, that's $200. Then you would have already paid off your fine and court costs by working at a nonprofit organization. Okay. Now, everyone that's here, as I mentioned earlier, you've been arrested, bonded out of jail. Jefferson County has a program for first-time offenders. If you haven't been in trouble before, then when I say Jefferson County, I'm talking about the district attorney's office. They have a program that is called pretrial diversion. With pretrial diversion, they will dismiss your case, and if you complete the program, you can get the case expunged from your record, meaning that erased, deleted, or wiped off from your record, your criminal record. It's like it never happened. It's no longer there. Now, in order to qualify, it has to be your first time getting into trouble. And we're talking about, when I say use the term trouble, I'm talking about having a criminal cases. And then you have to get an attorney to assist you at making the application to get into the pretrial diversion program. And then the third thing is, it cannot be for an offense involving unlawfully carrying a weapon or resisting arrest. For all other charges, all other misdemeanor charges, you are eligible for pretrial diversion if it's your first time getting into trouble or getting in trouble with the law. Now, this court, County Court at Law number 2, has a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office. The program is designed to address the issue of what we call recidivism. Recidivism is when people commit crimes over and over. And so with this program, the program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. And the way the program operates is we have partnerships with local agencies in the Jefferson County community. One agency we have a partnership with is Spindletop Center. Spindletop Center, which is our local mental health agency in this the Southeast Texas region. And we have some folks here from Spindletop. They're going to come to you and tell you a little bit more about the program that Spindletop has to offer. But basically, the program that is designed is basically Spindletop can do a private interview either here in our conference room. They can do it at their office by phone. They can do an assessment. They could develop a treatment plan for either outpatient or inpatient treatment. Now, in order to qualify for the program, you do not have to be incompetent or insane. You could merely suffer from depression or anxiety or any host of other mental illnesses. And Spindletop has the expertise and knowledge to address your mental health needs. Spindletop also has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OZAR. OZAR stands for Outreach, Screening, Assessment, and Referral. Both of those programs are programs that are drug and alcohol related or counseling programs. And what they will do, they will hold a private screening, do an assessment, and you could either be referred to either outpatient or inpatient treatment. And if you are unemployed or you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once a person is trained in any one of those areas that they select, then CICE will assist them at getting a job in the area that they're trained in. Now, if you have not graduated from high school and you would like to get your GED, CICE has a GED program where you could get your graduate equivalency diploma. Now, all of these programs that I just mentioned are free. Does not cost you any money. The only thing it may cost you is some time. And I like to say in this court, we don't just give time, we take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people, we can make Jefferson County a better place for all of us to live, work, go to school, raise our families, and go to church. And I like to say in this court, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community in which they live. Why? Because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. And we have brochures and we can point you in the right direction so that you can take advantage of this program. And the other thing about this program is this. All of these programs that I just mentioned can be used as community service. So for example, let's say you were ordered to pay a fine in court costs. You could not pay, you can't pay the fine in court costs because you do not have the income. No problem. We convert the fine and court costs to community service. And while you're doing community service, if you decide to say, well, I think I might go take advantage of this mental health issue that I'm having, for every 1 hour that you're sitting in that program, $12.50 will be going toward payment of your fine. And 1 hour will be go toward community service. So maybe you say, well, I might look into see if I could get a better job. And let me go look at this job training program that they have at Lamar. Every hour that you're in class being trained to do a job, 1 hour is community service, and the $12.50 is going toward payment of your fine and court costs. And the same thing is true for drug and alcohol. While you're getting drug, alcohol treatment, or counseling, every 1 hour that you do, $12.50 will go toward your fine and court costs, and 1 hour will go toward the program. So I tell people this: it's like killing 3 birds with one stone. You're in the program, you're paying your fine and court costs, and you're doing community service. You're doing one thing, but you're getting credit for 3. So if you're interested in those programs, just feel free to let us know, and we have some brochures. Now, as I mentioned to you earlier, these programs were started back in March of 2017. And so Spindletop has helped probably thousands of people since they've been involved in this program. Program is very effective. And now we're going to have some folks from Spindletop. We have Chris and Deputy Hinton, who's going to come forward and tell you a little bit about the program that Spindletop has to offer.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Stephen Hinton. I'm a deputy licensed by the State Commission here in the Sheriff's Office. Co-worker Chris. Chris is a qualified mental health professional with Spindletop. The reason we are both here this morning is because the judge cares about every single person that comes before the bench. What the judge has found, and what statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with your particular situation.
When you said mental health needs like the judge said, anxiety, depression, things that occur for everybody at some point in their lives that are not necessarily made easier during the court process. There's a lot of really great community resources, and whenever the judge speaks about outpatient, inpatient, we can get information on inpatient, but we can only really refer to outpatient. There's a lot of really great resources in this area for education, for housing, for just financial assistance, or just to have somebody to talk to that are well funded, but they're not well advertised, and that's kind of where we came in.
So whether this is your first time to be in court or your 10th time to be in court, there's still hope. In fact, what we're offering you today has the ability to change your life, but we're going to need something from you. We need you to share that need with us. And Chris will explain how you can do that very privately.
When you guys came in, I handed this out to everybody. This functions as a baseline HIPAA consent form. The reason I handed it out to everybody is because we function as a loophole in the court. The good thing is it doesn't matter if you're here for yourself or you're here to support for somebody else. It doesn't matter if you need information for yourself or you have somebody you care about that you just want to find out a little bit more about what's in the area for. It doesn't matter if you're here, like it doesn't matter if you live in Jefferson County and you come to court in Jefferson County. It doesn't matter if you're on the other side of Texas. If you need something, we can find it for you. All this is, it functions as a baseline HIPAA consent form so that you know that your information is protected under state law. The only person who will see this is me. The only person who will reach out to you is me. I will only reach out to you once, and then every continue with you want to keep working. Anything I help you get set up with is going to either be slightly detailed or state funded, because we know that financial stress is a big factor. Sometimes anxiety, depression, sometimes any kind of mental concern, it's requirements where there's something that you need to set up or something that isn't being met, and maybe it's causing other emotions. So we look at it kind of holistically, where we're trying to address everything. We're in here to help, where it's all we're here to do. At the bottom of the form, it does have an option to speak privately with me today. If you select that and we aren't able, I know that the court sometimes moves at a faster pace. If we're not able to talk today, I can call you. We can set up a time. I know that sometimes it's difficult to open up in this environment, but it's not a therapeutic environment, right? It's not a place that's really, you come in and it's hard to just be open and candid and discuss things in your past that maybe are affecting you. We can set that up. Sometimes the resource that people need is just support, right? That's why we're here. If you select that yes on here and we don't get a chance to speak today, I promise you will talk to me. We will sit in person if you want. We'll talk over the phone. It's up to you guys. It's whatever makes you most comfortable and just whatever you need.
We also have a flyer I want to make available to everyone here today. I don't think I have enough for everyone, but I will make it available for those who would want that. But on the back, it tells you a little bit of some of the advantages of actually participating in the program. It also has a 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number and get help immediately.
So that is the first resource we can give you. As I said, we actually, people come to Gordon, Jefferson County, they're not from anywhere near this area, right? That is active almost statewide. I say almost because you got some areas that just don't have self-service in Texas. But they are 24/7. It doesn't matter if you call them at 6 a.m. on Christmas morning. If you need to talk to somebody, they will be there. It's just about having access to it. Now, I know he said he doesn't have enough to give to everybody right there. On the bottom of your form, it actually has that number too. If anybody wants to write that down or put it in your phone or just whatever you may need to do, it is there as well. It's in a couple different places, but if you want one of those, we will get that to you and we will have more soon.
So just a little bit, the court is going to go into recess. When it does, we'll be coming out there visiting with each of y'all. If you have any questions, we'll be able to answer at that time. We'll pick up those documents from you and I'll get these out to whoever would like to have it as well. Thank you,
Okay.
Your Honor.
Thank you, Chris and Deputy Hinton. Now, ladies and gentlemen, before we go into recess, I just need to give you some instructions or give you some information. The paperwork that you have on the tablet, okay? We need you to fill that paperwork out. If you need assistance with filling the paperwork out, we have our court personnel who will be happy to assist you with filling the paperwork out. Once the paperwork is filled out, we're going to pick that paperwork up from you. I'm going to evaluate it. And then we're gonna have you to come before the court individually. And when I say before the court, it's gonna be right here in front of the bench, right in front of this table that's before this bench. Then, and once you finish here, then you'll go to the court coordinator. And if your case is reset, she'll give you a reset date for you to come back. Or if the case is being disposed of today, then you'll talk to one of the two prosecutors that's in here. Now, if you need to use the restroom, there are two restrooms right outside the hallway. The men's restroom is right in front of County Court at Law number 2. And on the opposite side of the hall from County Court at Law, that's County Court at Law number 3. On the opposite side of the hall is the 172nd District Court. The women's restroom is in front of the 172nd District Court. Now, please do not leave the courthouse, because if you leave the courthouse and if you call your name and you do not answer, your bond can be forfeited or will be forfeited, and a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, we're going to try to get through this process as fast as we can, okay? So, again, if you need some assistance with filling the paperwork out, just simply raise your right hand. We have our court personnel who's here who will be happy to assist you with filling the paperwork out. So at this time, the court will be in recess, and Deputy Hinton and Chris will come out and talk to you. Jefferson County Court at Law number 2 is back in session. The court is in session with the arraignment docket. First case is cause number 23 CCCR 2036. Case is style of state of Texas versus Jerica Janae St. Julian. Ms. St. Julian, your full name is Majerica Janae St. Julian. Ms. St. Julian, would you please raise your right hand? Ms. St. Julian, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. St. Julian, you may put your hand down. How are you doing, Ms. St. Julian? That's good. Ms. St. Julian, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials on the line that state you would like to hire your own attorney?
Yes, sir.
Now, Ms. St. Julian, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Ms. St. Julian, your case is going to be reset to give you an opportunity to hire your own attorney, and our court coordinator will reset your case. But before she resets your case, I have some bond conditions that I need to go over with you, and the bailiff is going to hand them to you. The document that's just been handed to you, Ms. St. Julian, is titled Standard Bond Conditions in County Court at Law number 2. Do you see that title?
Yes, sir.
Okay, I'm going to go over these bond conditions with you. And it reads as follows. Following the return of criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit the offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes.
Now, condition number 4 does not apply. However, condition number 5 does apply. Condition number 5 states that the defendant is prohibited from possession of firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Okay, now, Ms. St. Julian, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant can be issued for your arrest. And if a warrant is issued for your arrest, you'll be arrested and placed in Jefferson County Jail. Do you understand?
Yes, sir.
Okay, now, the court coordinator is going to reset your case. You're going to have a seat. Oh, just go to her window, and you have a blessed day. Next case is cause number 23 CCCR 1934. Case is style of state of Texas versus Donovan Washington. Mr. Washington, your full name is Donovan Washington.
Yes, sir.
Okay, Mr. Washington, would you please raise your right hand? Mr. Washington, do you swear, affirm, and tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Washington, you may put your hand down. How are you doing, Mr. Washington?
Good.
I'm doing fine. Thanks for asking. Mr. Washington, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this I mean, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you want to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document here that's titled waiver of counsel for purposes of entering a guilty plea or proceeding the trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Washington, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Washington, have a seat. And one of the prosecutors will come out and talk to you.
Yes, sir.
Washington. Next case is Nicole Newell. Miss Newell, your full name is Nicole Newell. Ms. Newell, would you please raise your right hand? Ms. Newell, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Ms. Newell, you may put your hand down. How are you doing, Ms. Newell? You good? That's good. Now, Ms. Newell, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
And is this your signature on the line that's titled defendant?
yes,
Are these your initials on the line that state you would like to hire your own attorney?
yes.
Now, Ms. Newell, before you signed and initialed this document, did you read the document?
Yes.
Did you understand what you read?
Yes.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Ms. Newell, you're gonna have a seat where?
She can just have a seat.
Okay, now, Ms. Newell, our court coordinator is gonna reset your case, give you an opportunity to hire your own attorney. You're gonna have a seat in that first chair on the wall. Once you finish at her window, you're free to go and you have a blessed day. Next case is cause number 23CCCR 2216, cases style of state of Texas versus Christopher Frazier. Mr. Frazier, your full name is Christopher Frazier.
Yes, sir.
Let's see. And it's Christopher Logan Frazier. Mr. Frazier, would you please raise your right hand? Mr. Frazier, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Mr. Frazier, you may put your hand down. How are you doing, Mr. Frazier? That's good. Now, Mr. Frazier, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document here that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document? And is this your signature on the line that's titled defendant? Mr. Frazier, before you sign and initial these documents, did you read the documents?
Yes, sir.
And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Frazier? Just have a seat and one of the prosecutors will come out and talk to you. Next case is cause number 23CCCR 21 1-6, case of South State of Texas versus Gregory Warner. Mr. Warner, I'm doing fine. Thanks for asking, Mr. Warner. Is your full name Gregory Allen Warner? Mr. Warner, it is?
sir.
Would you please raise your right hand? Mr. Warner, do you swear or affirm to tell the truth? The whole truth and nothing but the truth, so help you God. Mr. Warner, you may put your hand down. How are you doing, Mr. Warner?
I'm good, how are you?
I'm doing fine. Thanks for asking. Now, Mr. Warner, I have before me two documents, or a couple of, yeah. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you would like to apply for court-appointed attorney?
Yes.
I also have another document that's titled Jefferson County Affidavit of Insurance. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Now, Mr. Warner, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, now, Mr. Warner, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Peter Doyle. Attorney Doyle will be giving, Peter Doyle will give you information, will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go. And now, before she gives you that information, I need to go over some bond conditions with you, Ms. Bailiff. Hand this to Mr. Warner. Mr. Warner, the bailiff has just handed you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes.
Okay, now, I'm going to go over this document, which and it reads as follows. Following arrest and or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Now, condition number 3 does not apply. However, because you have a DWI second, condition number 4 does apply. And condition number 4 states a defendant who has been arrested or accused of any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to court on or before the 10th day after arrest. Do you understand that condition?
Yes.
Oh, let me do this here. Actually, it should be submitted to the court on or before, it should say 3 days after the day. Ms. Bailey, could I get that back from us? I need to make that correction.
Judge, I got the portable when, referendum. I mean, come, that
Okay,
we called and request for portable referendum.
he has bond conditions? Okay, let's see if he has some bond conditions.
It's through the ball.
He might already have bond conditions. Okay, so I'm gonna have to, we don't have nothing right, I need to write that in. Uh, who did we have? Yes. Mr. Warner, I'm gonna read the condition number 4. Well, yeah, I'm gonna read condition number 4, 5, and 6. Condition number 4, defendant who has been arrested or accused of any subsequent offense listed under section 49.04 through 49.06 of Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device that doesn't make, it doesn't match up. Let's see it. Yes. Okay, that makes vehicle. Vehicle. Oh, here it is. Okay. Okay. Now, condition number 4 states that the defendant who has been arrested or accused of any subsequent offense listed under section 49.04 through 49.06 Texas Penal shall not operate any motor vehicle unless the vehicle is equipped with an interlock device that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breadth of the operator and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court only before the date scheduled for the defendant's initial appearance. Now, you do not have a motor vehicle, is that correct? And you're not operating a motor vehicle. So the defendant shall, number 5, the defendant shall obtain, maintain, pay for, and have no violations with the initial interlock device, mobile breath device. Any violation will be grounds for revocation. That's number 5. Number 6, the defendant must attend AA 3 times a week and provide proof to the court. And we have some paperwork here that we can provide you with. And that paperwork have information on locations where you can attend the AA meetings. Our court coordinator is going to reset your case, and you'll be given a copy of these bond conditions.
Okay.
Just make a copy. You can have a seat in that first chair by the wall.
You wanna hand this to him or just?
You can give him the copy. Okay, I'll take that. I need to give him the paperwork for the AA meeting. You need to give it to her. And I need to give. Yes, this is when you go to AA meetings, and this is a schedule and locations. And what you're gonna do, you're gonna have this information filled out every time you go, and you'll bring this back to court when you come. Okay, you're free to go and you have a blessed day. You are.
The door right here is locked. You gave me your receipt already? Yes.
Okay. Thomas Robin. You've come far. This is cause number 2360 Sierra 2408. Case is style the state of Texas versus Thomas Pierre Robin. Mr. Robin, is that your full name?
Yes, sir.
Mr. Robin, would you please raise your right hand? Mr. Robin, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Robin, you may put your hand down. How are you doing, Mr. Robin?
Kind of got a migraine, but hanging in there.
Okay. Okay, Mr. Robin, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And is this your signature on the line that is titled Defendant?
Yes, sir.
Mr. Robin, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Robin, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Mark Faggett. Attorney Faggett will be given information to contact you. And you will also be given information to contact Mr. Faggett. But before the court coordinator give you that information, I need to give you some bond conditions. Would you please step right here and get these bond conditions, and you can step back. Mr. Robbins, the document that you've just been handed is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
I'm going to go over these bond conditions with you, and it reads as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or orders subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? Now, condition number 4 and 5 does not apply. However, on page, but condition number, 3 and 4 does not apply. However, condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Now, Mr. Robin, if you violate any one of these conditions, your bond will be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Mr. Robin, just have a seat in that first chair by the wall. And when the court coordinator is ready for you, she's gonna call you up to a window. You're welcome. Next case is cause number 23-CCCR 2638. Case is styled the state of Texas versus Anaya Griffin. Oh, okay. Next case is Bobby Lee Joseph Jr. Cause numbers 23-CCCR 0944 and cause number 23-CCCR 1148. Please stand in the front of the bench, Mr. Joseph. Mr. Joseph, your full name is Bobby Lee Joseph Jr. How are you doing, Mr. Joseph? I'm doing fine, thanks for asking. Mr. Joseph, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And the second document is titled Affidavit, Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Is this your signature? Okay, Mr. Joseph, before you signed and initialed these documents, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Joseph, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Benjamin Jeffries. Attorney Jeffries will be given information to contact you, and you will also be given information to contact him. Our court coordinator is going to give you that information. Once you get the information from the court coordinator, you'll be free to go and you have a blessed day. Now, before we do that, I need to get you, I see where you initial on the side here, but we need you to initial on the line that have the check that indicates that you're applying for a court-appointed attorney. Okay? You have a pen for him? Thank you. Mr. Joseph? Let me do this. I'm gonna white out the where you had your initials on the side. Now, you need to step right here. That's the document, and this is the pen. You're gonna put your initials on the line that has the check mark. Thank you. All right, now, Mr. Joseph,
Yes, sir.
you can just have a seat in that first chair by the wall, and then when the court coordinator is ready for you, you can actually come to one once you finish at the window. You're free to go and you have a blessed day. Ariana Michaela Kinsey. Miss Kinsey. Your full name is Ariana Michaela Kinsey? Ariana Michaela Kinsey. Miss Kinsey, would you please raise your right hand? Miss Kinsey, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may put your hand out. Miss Kinsey, you need to take the gum out your mouth. There's a trash can to your right on the side of that table. Thank you. Now, Miss Kinsey, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? Or did your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Now, Ms. Kinsey, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Kinsey, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, And you will also be given information to contact him. The court coordinator is going to give you that information. Once you get the information from the court coordinator, you will be free to go and you have a blessed day. Please have a seat in that third chair on the wall. Okay, your full name is James A. Sanguine.
James Allen Sane.
Okay, Mr. Sanguine, would you please raise your right hand? Sanguine, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Sanguine, you may put your hand down. How are you doing, Mr. Sanguine?
We're trying to make it, I bet you.
I'm doing fine. Thanks for asking, Mr. Sanguine. I have before me a document that is titled Judge's Explanation of Rights to Defendants by Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes, sir.
Defendant? And are these your initials on the line that state you'd like to hire your own attorney?
Yes, sir.
So Sanguine, before you signed and initialed this document, did you read the document?
Yes,
Did you understand what you read?
yes,
And is everything in this document true and correct to the best of your knowledge?
yes, sir.
Mr. Sanguine, your case is going to be reset to give you an opportunity to hire an attorney. And our court coordinator is going to reset your case. Please have a seat on the fifth chair on the wall. And once you reset your case, you're free to go and you have a
Thank you
blessed
very
day.
much, sir.
You're welcome. We have Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 23 CCCR 2216, case is styled the state of Texas versus Christopher L. Frazier. Mr. Frazier, is that your full name? Mr. Frazier, would you please raise your right hand? Mr. Frazier, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Frazier, you may put your hand down. How are you doing, Mr. Frazier? You doing good? That's good, Mr. Frazier. I have before me a document. Let's see. Actually, I have two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Frazier, do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials on the line and state you want to waive your right to an attorney to represent yourself?
Yes, sir.
I also have another document that's titled Waiver of Counsel for purposes of entering guilty plea or proceeding to trial. Do you recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Frazier, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Frazier, I also have before me a document that is titled Standard. Also have a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. Now, before we go any further, Mr. Frazier, let me do this here. Mr. Frazier, you have a right to have a court reporter to type down or dictate everything that's being said. You also have a right to give up your right to have a court reporter to type down everything that's being said. Do you waive or give up your right to have a court reporter to transcribe the this proceeding?
Yes, sir.
Okay. Now, Mr. Frazier, I also have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Christopher L. Frazier, on or about August 14th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of unlawfully carrying a weapon. Do you understand what you've been charged with? And to this charge, Mr. Frazier, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Now, Mr. Frazier, I also have before me a document that is titled Misdemeanor Plea Admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are two sets of initials. The first set of initials is on a line next to a box. Just check nolo contingere, which means no contest. Did you place your initial on this line? And the next set of initials is below a paragraph that is titled Discovery Admonishment. And your initials are on a line next to a statement that reads as follows. I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there, he have his initials. You need to
That
put
is the signature, Your Honor.
Okay. Now, is this your signature on the line that's titled defendant?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Frazier, before you signed and initialed these documents that I just showed you? Did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes,
Mr. Frazier, are you a citizen of the United States?
yes, sir.
State up for stage one.
Mr. Frazier, the state is offering State's Exhibit Number 1 into evidence. State's Exhibit Number 1 is this document that you acknowledge. This is the same document that have your initials on page 2 in the 2 locations and your signature on page 3. The state would like to use this document as evidence against you in your case. Is it all right for the state to use this document as evidence in your case? Okay, no objections. State's Exhibit Number 1 will be admitted. Mr. Frazier, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Frazier, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that your pleas and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
The agreement for a plea of guilty or no contest, the state has offered 90 days probated over 1 year with the fine in this case waived, 40 hours community service, and the defendant has agreed to flip his weapon involved in this case.
And you say 40 hours of community service?
Yes, Your Honor.
What's the court cost in this case?
277.
Mr. Frazier, the state is offering that you serve 90 days in the Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you will not be required to pay a fine because the fine is being waived. You will be required to pay court costs in the amount of $277. You'll be required to pay a probation fee in the amount of $60 each month, a urinalysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is a total amount that you will be required to pay each month, is $108 a month. Will you be able to pay the $108 each month?
Yes, sir.
You will also be required to perform 40 hours of community service. Now, I have a motion before me that is titled Motion to Forfeit the Weapon to the Beaumont Police Department. Do you recognize this motion to forfeit?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And before you signed this document, did you read the document?
Yes, sir.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Mr. Frazier, do you want the court to grant this motion to forfeit the weapon to the Beaumont Police Department?
Yes, sir.
Mr. Frazier, the court is granting this motion to forfeit the weapon to the Beaumont Police Department. And Mr. Frazier, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Frazier, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Frazier, this will conclude your case. However, I need to give you a written admonition on the ineligibility to possess a firearm or ammunition. Would you please step forward, get this document, and then you can step back. I'm going to go over this document with you, and it reads as follows. Written admonition of ineligibility to possess a firearm or ammunition. In accordance with the Texas Administrative Code, Section 176.1, the court hereby admonishes you of the following. Number one, you are, by entry of order or judgment, ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code Section 46.013A, firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. B, firearm does not include a firearm that may have, as an integral part, a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is one, an antique or curio firearm manufactured before 1899, or two, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure, Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code, Section 46.02, Unlawful carrying weapons. Penal Code, Section 46.04, Unlawful possession of firearm. Penal Code, Section 25.07, Violation of certain court orders or conditions of bonds in a family violence, child abuse and neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code, Section 85.026, warning on protective order. Now, Mr. Frazier, the written admonition that you have been given, that you have been given by the court, is for your records. This will conclude your case. You need to stand in front of the court coordinator and the bailiff, and you will follow their directions. Okay,
Thank you.
is the bailiff here? Okay, just have a seat in that first chair. Next case is cause number 23 CCCR 1934. Case is style State of Texas versus Donovan Travis Washington. Mr. Washington, your full name is Donovan Travis Washington.
Yes, sir.
Mr. Washington, would you please raise your right hand? Mr. Washington, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Washington, you may put your hand down. How are you doing, Mr. Washington?
Good to hear.
I'm doing fine. Thanks for asking. Mr. Washington, I have two documents before me. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. And do you recognize this document?
Yes, sir.
And is this your signature on the line? It's titled
Yes, sir.
Defendant. I know these your initials on the line that state you would like to waive your right to an attorney and represent yourself.
Yes, sir.
I also have another document that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Washington, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Mr. Washington, I also have a document before me that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, Mr. Washington, it alleges that you, Donovan Travis Washington, on or about August 7th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of harassment. Mr. Washington, do you understand what you've been charged with?
Yes, sir.
And to discharge Mr. Washington, how do you plead guilty, not guilty, or no contest?
No problem.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Washington, I also have a document before me that is titled Misdemeanor Plea Admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials in two locations. First, the location of the first set of initials is on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
Right here. The second set of initials is below a paragraph that is titled Discovery Admonishment and is next to a line that has a statement that reads as follows. I do not request discovery of the evidence I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
Now, before we go any further, forgot to mention that as a defendant in a criminal case, you have a right, you have a court reporter to dictate everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up the right to have a court reporter?
Yes, sir.
Okay. Now, on page 3 of this same document, there is a signature above the line that is titled defendant. Is this your signature?
Sir.
And on the next document that is titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Now, Mr. Washington, before you signed and initialed these documents, did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Washington, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit 1 into evidence?
Yes, Your Honor.
Now, Mr. Washington, the state is offering State's Exhibit number 1 into evidence to be used against you as evidence in this case. State's Exhibit 1 is the document that you acknowledge. The same document has your initials on page 2, and it also has your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Mr. Washington, are you a citizen? I think I asked you that. Are you a citizen of the United States?
Yes, sir.
Okay, now, Mr. Washington, is there any evidence that you are currently mentally incompetent to stand trial?
Yes, sir. I go to Spindle Town.
Okay? Okay, let me do this here. Pursuant to Article 1.24 of the Texas Code of Criminal Procedure, all rights, all trials and proceedings shall be public. However, pursuant to the case of Lilly versus State 365, Southwest 3rd 321, the right to public trial is not absolute and may be outweighed by other competing interests, such as the non-disclosure of public information, in the interest of security, and to ensure that a person get a fair trial. Now, Mr. Washington, based on some questions I need to ask you, the questions will disclose non-public information. So of the abundance of caution, the court is going to close this proceeding to the public. Now, when I say the public, we are on YouTube. And the court makes the following findings. The court finds that the closure of this hearing is no broader than necessary to protect the defendant's interest, to prevent the non-disclosure of non-public information. And the court has considered other reasonable alternatives. And the court make these findings, and these findings are adequate for the closure. And at this point, this particular